Next thing I want to do is just very quickly look at data protection. That's the second big point. Again, everyone understands the data protection and data security issues in the cloud. I'm going to assume you understand a little thing about personal data protection, and I want to just zone in on 4 very recent developments rather than go back and bore you with all the basics. First, I want to mention an opinion 1 of 2010, issued by the Article 29 Working Group. What that is a bunch of the data protection commissioners from all 27 countries in the European Union meet very regularly, perhaps quarterly, I think, and they issue lots of papers on very important data protection issues. Very recently, they issued a paper, which paper opinion 1 of 2010, and what that does, it's very neutral in the way it's articulated. It doesn't really talk about cloud computing, because law should be neutral. It shouldn't really buy into full technology expressions because it needs to remain neutral, because it tends to last longer than technology sometimes. But this opinion it issues does recognize the existence of cloud computing type services. And what it does is it seeks to clarify the difference between a data controller and a data processor, because each have a different suite of obligations under European data protection law, and the concepts are often very blurred. And even as experienced lawyers who deal with these concepts on a daily basis, we still struggle sometimes to work out, are you a data processor or both a processor and a controller? So this opinion, what it does is it looks at a lot of these difficulties presented by cloud computing services, and it seeks to give a lot of clarity via a number of case studies. So it's very interesting, and it shows that the data protection commissioners at a pan-European level are looking at this and seeking to give clarity. Secondly, the European Commission, one of the big data protection issues is the movement of personal data outside of the European Economic Area. Within the European Economic Area, there's essentially the free movement of personal data. I could qualify that, but in general, that's the principle. Whereas exporting it outside of the European Economic Area is more fraught. It is possible, but you must fall within a number of exceptions. One of those exceptions is the person you're exporting it to, say in the US, must sign a model form agreement. The problem with cloud computing was the recipient, the processor in the US, invariably used sub-processors or a back-end infrastructure provider. And you didn't have, the model form agreement didn't cover that sub-processing. So this new model form agreement issued by the Commission permits you to export your data to the US, even if that recipient in the US, the importer, uses sub-processors. So again, it's a specific law designed to assist problems presented by cloud computing. Data breach notification, this is the whole, in order to, sorry, I should fly ahead here. Security breach notification, in order to give people confidence around cloud computing and personal data treatment generally, one needs to know if your personal data is being compromised. It would be helpful if you knew that, especially if it involved your credit card details. So in the US, for the last 8 or 9 years, there's been a proliferation of security breach notification laws requiring companies who suffer a security breach to notify the underlying data subjects pretty promptly, and that's mandatory law in the US. Europe has not followed that approach. At a federal level, if you like, but certain countries like Germany and now Ireland are moving along the road of security breach. So there's a draft code of practice issued by the Irish Data Protection Commissioner, which I would expect will crystallise into law later this year, which is going to create a mandatory security breach notification regime, subject to certain de minimis exceptions, but they are really de minimis. It's if less than 100 people are affected, or if the data, the subject matter of the security breach is fully encrypted, well then you have a carve out. But otherwise, if personal data is compromised, you will have to notify the Data Protection Commissioner. So from a consumer's and a user's perspective, that's comforting. It gives people a little bit more confidence in their use of cloud-based solutions, because they know at least if their data is compromised, the Data Protection Commissioner will learn of it, and they in turn will probably learn of it because the Data Protection Commissioner will probably order the company to notify the underlying data subjects. The Irish law, unfortunately, does not have, or the proposed law doesn't have a materiality threshold like a lot of the laws in other countries. So this is a little bit annoying from a vendor perspective. It means that if there's any type of compromising of your personal data, you will have to go and notify the Data Protection Commissioner, even if you think it's really basic data, such as just a list of names, coupled with one very basic, benign piece of personal data. So there's no material, there's no issue, well, is this personal data, will it really damage people? Will they suffer? Will their privacy rights be infringed? It's irrespective of what type of personal data you'll have to notify. But as I said, this security breach code is in consultation mode, so feel free to make your submissions and say there should be a materiality threshold like in Germany, like in Australia. I mean, from a vendor perspective, this may result in additional cost, in that if there's a security breach, you'll have to issue a report report to the Data Protection Commissioner and possibly a subsequent report showing remediation measures. But as I said, I think in the main it will help increase confidence. The final thing I want to mention, this sort of hot off the press, I don't know if you know Schleswig-Holstein. It's one of the German states up north near Denmark, and I think historically it's been involved. Denmark has claimed it a number of times over the years. But the data protection in Germany, being a federal-based system, it has each state, if you like, has its own data protection commissioner in addition to its sort of overarching data protection commissioner. So the data protection commissioner from Schleswig-Holstein 2 weeks ago issued a paper, and they did the most intensive study of cloud computing and data protection law that has ever been conducted by a regulator, and issued a fairly I would say, a fairly scathing report in some respects of the compatibility of the cloud with data protection. Now you must understand, this isn't even German law. This is an interpretation by an administrator in a state in Germany, but it's salutary and one should not ignore it. I mean, what they did say, amongst other things, they said that there's always been a view in industry that, you know, if you have your SAS 70 type compliance, well then you should be complying with your legal obligation to keep data secure. And the commissioner in Schleswig-Holstein said that's not the case. Compliance with SAS 70, that does not mean you're complying with your legal obligations. So he tore that up immediately. And then he had to go at a few other things. He basically said that exporting any personal data outside of the European cloud will be illegal per se, even if it's to 2 or 3 authorized countries, which the European Commission have said have adequate safeguards. So again, a pretty radical thing to say. On the upside, they did say that there are ways to do it using the model form agreement I mentioned earlier. They've said that if you do it using another way, called binding corporate rules, that's lawful. But the point is that this opinion, which they have produced, it is a little bit worrying from an industry perspective. And I know from talking to my German colleagues that they tend to, in Germany, they're very concerned around data protection, and their view is that if you're going to use cloud computing, it must be a European cloud. And that's clearly what the German Data Protection Commissioner of Schleswig-Holstein is saying. I mean, legally, under European law, that's not necessarily the case. One can export data outside of the EEA. It's just you have to tick one of the 4 or 5 boxes. So as I said, it'll be interesting. One would hope that that very conservative position won't permeate out and become the key position. It's unfortunate this is the first position from a European regulator, and it's not the most positive from a development of the cloud perspective. So finally, I just want to mention in terms of what's on the horizon, in European law, if you want to see what's coming down the line, you always look to the Commission, because a lot of key Irish laws, including our data protection law, they come from Europe and they're based on European law. So the European Commission produced a paper earlier this year called Opportunities for Cloud Computing Beyond. The Commission, at a lot of different levels, are buying into it, just like the World Economic Forum at Davos. And what they're saying is, you know, huge opportunity for the cloud. They want to drive it in every respect, smart economy, all of that. But again, ignoring the legal challenges. And they didn't get caught up in data protection, which is helpful either. They looked at certain other real legal challenges and business challenges. And one, they looked at the whole idea of portability and mobility and interoperability between cloud solutions. And they looked at the whole issue of proprietary clouds versus open source clouds. And obviously, as a government, administrative type organization, they obviously leaned in favor of the open source cloud. And they did, their view of the Commission is that cloud mobility, you know, the ability to port between cloud providers is at the essence of the success and the real large embracing by the user community of cloud services. And in order to do that, as I said, that there must be improved cloud mobility and portability, and they looked disfavorably on long-term lock-in. So I mean, there are just some thoughts coming out of the Commission. The Commission may not regulate or legislate in that regard, but I guess if they felt after a number of years that these continue to be impediments, it is certainly conceivable that they could, and they certainly have the power to legislate in that regard. So that's about it in terms of just some kind of thoughts as to what's going on in the legal world of cloud computing. I'll pass you back to Richie. Yeah.